talking too much.
Sharon and his fans, you know,
Yeah,
he really did.
I think he built himself up and worked through his health stuff to get to that concert where he sounded fantastic.
Warrior Island, a paradise of sun, sea, and second chances, where creators fly in for fame and lawyers fly in for opportunity.
It's me, Corona Believer.
I'm ready for them at this point to say, let's change all the stoplights so red means go and green means stop.
Yeah. Oh, that would be great.
And how I am right now is how I am all the time. What you see is what you get. If you don't like it, sorry.
Tori, say it, Tori. Say it, Tori.
I don't. It's not midnight. I can't drop the F-bomb on Lisa's channel.
Listen, this person doesn't need a guardian and therefore shouldn't be given a guardian.
So many victims that want to tell their story.
There's a man named Robbie.
It's the Burmese. Oh, and she's gonna squeeze it and make it come out. Oh, it's the jizz.
Very grateful to come back.
Yeah. Water bowl in that one.
Other people can hear.
Hello?
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 What is happening? Hello?
What's going on? What's this emergency?
What's breaking news? I don't know. What? I woke you.
What's going on?
Hello, losers. Wait till there's more people come. More people's coming.
Yeah.
John
Get
said,
Ray on here. Ray's on the chat. Get Ray in here. Ray, send Ray a link.
yeah, I did. I sent Ray a link.
Ray, get on here.
What's
like a
up,
party
losers?
We're partying on a Tuesday night. I love it.
John Cook says, hey, Lisa, I'm sorry I woke you. John, you can wake me up like that anytime you want.
Oh, this is great.
This is great news. I was sleeping, guys, and yes, I'm just, I just got news. So I figured, oh, well, we all need to discuss this. So, all right, I got some peeps coming on and joining us. So we're just gonna wait a minute and see who's all gonna show up.
Oh wait, Super Dave's on there. Get Super Dave in here.
Super, I sent you a link.
What's up, Bearded?
Oh my God, you don't know,
It is a
Dave?
great-
Get in here. Get in
it's
here.
A great day. It's a great day, Bearded. Great day.
There's Lynette is in the chat. Hallelujah, hallelujah. Here we go. Mr. Ray Bone Crusher is here.
What's up, Ray?
There's Ray.
How you doing? How you doing? Let's get everybody in here. Bud Light! Yes, Bud Light is here. Yeah. What's going on? Marla. Hello, everyone. Hello, Sandra, QG, John, Lynette, they're here. I'm sorry, Michelle. Red Road, Patty. Everybody get in here. We got some good news. Tanya.
Even Jules
Bearded.
is here.
Yeah, Jules is here. What's going on?
Can you guys hear me?
Thanks. Shauna, Danielle, Megan, Storage Bots, Nicole's here. Tank Girl, Kevin James, Jackie Ridge, everybody. Come on. Starbucks. I'm so excited right now.
You guys hear me okay?
What? Hey, Ray.
Yes.
Ray, how you doing? I'm sorry, you were live, weren't you?
How you doing, Kim?
Yeah, but I got off right away. Can you hear me?
Yes, I can hear you fine. And
more
here
right.
is Super Dave.
Super Dave.
What's going
It's a
on?
party up in here.
Oh, yeah.
Jules is absolutely excited. We're all excited over here. I was so excited. I couldn't even see straight. I had to call Rich. I'm like, is this what I think it is?
Yeah, it is.
I told you better call Red.
Oh my God. Did she just say Ray got off? That's so funny. Fresh. Ray.
She was in here
Smile.
crying. She was crying, trying to catch her breath. I'm like,
Ray.
hold on, just catch your breath. Call Richard or call Leslie.
I literally was out cold.
Richard.
I was out cold. Gabe, as usual, had he had the phone, right?
Right.
So Tori calls and goes, Tori's calling. And I was like, okay. He's like, Tori says you got to call. What did you say? You said something that John Cook.
Yeah, John Cook said something happened with the case.
Yeah, so I answer the phone and she's like, what? Is John saying you need to check the case or whatever? I'm like, all right. So I'll get up. I'm getting up right now. I jump up. I run to the computer. I sign it to Pacer. It wouldn't let me sign it. I'm like, oh my God, you're joking. So I open this and I start reading this. I'm like, wait a minute, what? And I got to a point where it came to my name and it said something. I'm like, no way. And I started reading. It said, the blah, 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 Lanham Act. And I'm like, oh my God. I saw Rich's name. And I'm like, I got to call Rich. I got to send this to Rich. Oh my God. Is this what I think it is? It was so funny. So here we are. So I said, he says, yes, it is. So I said, I'm going live. So he's like, all right. So here we are. And we have the documents. We invited everybody. We lost Super Dave.
Oh.
Get Gabe's own phone. Yeah. I kind of like
Thank you, Starbucks. Hey, Bonnie.
Open this one. Where's the grabbers?
It's going to be like, where were you when you found out? So, all right. So we invited a couple people. We're just hanging in there. Somebody ding. What's his face? Hold on. You.
Why is right here?
Coming on.
Will someone tell me what's going on?
I'll tell you in a.
You got to bring that over there and read it at the same time.
Yeah.
So that everyone can see it.
It's right here. I have it. That's why. He's it's just down there. That's all. It's just a placement where he's at.
All right.
Guys, I don't know how well I'm going to be at reading this tonight. Just so you know. Marla said 10 leaves in a positive gift forever. Says whoop whoop.
Yep.
I gave it for you. Hold on. Oh my goodness, guys. Oh my goodness. Super Dave.
We just lost Ray.
And we just lost Ray. Okay. Let's let everybody get adjusted here.
How's everybody doing? I was just getting ready to record my podcast and my email went crazy. Wikipedia just sent me like dismissed. Oops, did I break it?
Yes,
What?
you just did.
No, it's
Dude,
not.
what? Wait a minute. Back up,
Leave it to
Super Dave.
Dave.
What?
Leave it to Dave. Come on.
Yeah.
My email just went crazy.
It's not dismissed yet.
It's not dismissed
not yet.
yet.
Not yet. But
What-
I mean, he's going to
it's
object
hanging-
regardless.
It's hanging by a thread. Put it that way.
Yeah, totally hanging by.
Sorry,
He's gonna.
I just spoiled everything. Leave it to me. You
Yeah.
send me the link. You send me the link.
Yeah. Yeah, we're gonna next time when it's actually official, we're gonna wait to send Dave the link. We're gonna give like 5 extra minutes. We're gonna hold off.
Fair enough. Fair enough.
What's going
Now,
on?
You know, I took my time I was trying to get everybody to come on at the same time, so
I was
Dude,
like
I'm
fielding
working with
emails.
venomous snakes here. Tell me what the hell's going on.
Yeah,
Robbie-
because I don't know.
all right, hold on. Okay, we're waiting for more people to show up, so hold on. All right, let's just go. Let's just
Just
in
get
there.
started. Go for it.
All right, I'll be ready. Now, this is 45 pages. I'm going to read the report and recommendation. Does it go into the whole thing? All right, I'm going to read you the main thing, and then I think I'm just going to go right to the bottom, Rich. We could explain, anything that people ask or whatever, okay? So, all right, this was filed today. Report and recommendation.
By who?
This Judge Bolitho, Magistrate Bolitho.
She's gonna get to it, Robbie.
I know. Come on. Okay. Plaintiffs commenced this case against 10 defendants, 8 of whom are proceeding pro se. The operative complaint is a sprawling 74-page second amended complaint with pages and pages of YouTube links that borders on a shotgun pleading. Doc 76. Plaintiffs allege violations of the Lanham Act along with various state law claims. Currently before the court are motions to dismiss filed by 8 defendants. There's a footnote. Defendant Preston filed a motion to dismiss, but she subsequently declared bankruptcy, Doc 92. The bankruptcy filing resulted in this case being stayed as to defendant Preston, Doc 94. Thus, defendant Preston's motion to dismiss is not currently before the court. Also, not before the court today is the motion to dismiss recently filed by defendant Luthman. The clerk of court had entered a default against defendant Luthman, which is Doc 150.
I unlocked them.
Defendant Luthman has now appeared and moved to set aside the default and sought dismissal, Doc 156. Plaintiffs have just recently responded, Doc 158, and the court is going to go down to this one. Hold on.
We'll address.
Okay, we'll address defendant Luthman's motion at a later date after having had time to study the issues raised by the motion and the response.
Right. Go back up now.
Okay. I'm going.
Page 2.
Okay, here we go. Plaintiffs have responded in opposition to the motions to dismiss. For the reasons below, the motions to dismiss should be granted. Should I go through all of it?
Yeah, read the background. Let's hear how bad Jeremy is.
Okay. Plaintiff Jeremy Hales owns and operates a business, Plaintiff Elephant Shoe LLC, that generates revenue by posting content on social media websites like YouTube, Facebook, and TikTok. Plaintiff Hales has over 730,000 subscribers for his What the Hales channel on YouTube and over 327,000 followers for his What the Hales page on Facebook. Additionally, Plaintiff Hales sells stuff he finds in storage units on an auction website called Whatnot.
Stuff.
Defendants are various individuals scattered throughout the United States who Plaintiff Hales claims have joined together to form an anti-What the Hales media ecosystem. This ecosystem allegedly exists to harm Plaintiff Hales' business. 2 of the defendants, Preston and Cook, live near Plaintiff Hales' vacation home in Florida. In this lawsuit, Plaintiff Hales alleges that defendant Preston is liable for malicious prosecution and civil conspiracy, counts 1 and 8, and that defendant Cook is liable for civil conspiracy, count 9. One of the other defendants, Matskin, is an attorney from Massachusetts who previously represented defendants Preston and Cook in one of the other federal lawsuits filed by Plaintiff Hales. Plaintiff Hales alleged that defendant Maskin is liable for tortious interference with business relationships and conspiracy, count 5 and 7. Defendants Helm, Hughes, Teschendorf, Lee, Kesey, Raymond, and Luthman are all people, most with their own YouTube channels, who plaintiff Hales says have engaged in a civil conspiracy to harm his business. Defendant Lee is also alleged to have violated Florida's Deceptive and Unfair Trade Practices Act, count 2, and Lanham Act, count 3, and to have tortiously interfered with business relationships, count 4, in addition to civil conspiracy. Defendant Luthman is alleged to have violated Florida's sexual cyber harassment law, count 16. To help keep all that straight, here's a chart.
He made a chart.
That's work.
Didn't believe that. I was like, oh my God, he made a chart. Okay. So, okay, you got
visual
it all.
aids from Bolitho.
Yeah. Okay. In terms of relief, plaintiffs seek monetary damages against all defendants. Plaintiffs also seek injunctive relief against defendants Lee and Luthman. Procedural history. The original complaint in the case names some of the current defendants, but not all, Doc 1. The claims in the original complaint were defamation, civil conspiracy, tortious interference, and aiding and abetting. Defendant Helm filed a motion for a more definitive statement, which led to the court ordering Hales to file an amended complaint. In granting the motion, the court instructed Hales' counsel that he should familiarize himself with the 11th Circuit's precedent on shotgun pleadings before filing the amended complaint. Yep, I remember that. Let's see, where was I? Here we go. All right, plaintiffs then filed the first amended complaint, which is Doc 35. Plaintiffs later filed a second amended complaint, which named the current defendants and asserted claims involving civil conspiracy, tortious interference, FDU, TPA. That's the federal. What is that? Okay, whatever. And Florida's sexual cyber harassment law. It is a second amended complaint that the defendants now seek to dismiss. Discussion. In the pending motion to dismiss, defendants argue that dismissal is warranted under Rule 12b-6 of the Federal Rules of Civil Procedure for failure to state a claim on which relief can be granted. To survive a motion to dismiss for failure to state a claim, a plaintiff's complaint must contain factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. The show's case law, threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice. A court ruling on a motion to dismiss must accept the complaint's factual allegations as true, but legal conclusions are not entitled to the presumption of truth. A. Defendant Lee's motion to dismiss. The court will first take up Defendant Lee's motion to dismiss, Doc 106. As mentioned above, the second amended complaint alleges that Defendant Lee violated the Lanham Act, the FDU-TPA, tortiously interfered with business relationships, and participated in a civil conspiracy. Defendant Lee claims that the plaintiffs have failed to state a claim for each of these causes of action. 1. The FDU-TPA. In count 2 of the second amended complaint, plaintiffs claim that Defendant Lee violated this, and plaintiffs seek damages and injunctive relief as well as the attorney's fees under the FDU-TPA. Defendant Lee argues that dismissal is warranted for failure to state a claim. The court agrees with Defendant Lee. The parties disagree over whether claims brought under the FDU-TPA are subject to heightened pleading requirements found in Rule 9b of the Federal Rules of Civil Procedure. There is a dispute among the district courts in Florida on this issue. And it says, see case law, it is unnecessary to weigh in on that dispute today because the FDU-TPA claim does not survive under normal pleading standard found in Rule 8. Okay. The court will first discuss plaintiff's claim for damages under the FDU-TPA. To assert FDU-TPA damages claim, a plaintiff must allege 1. A deceptive or unfair act in the conduct of trade or commerce, 2. Causation, and 3. Actual damages. Although a plaintiff need not be a consumer to assert FDU-TPA claim, there must be an injury or detriment to consumers. A plaintiff may only recover actual damages. A plaintiff may only may only recover actual damages under the FDUTPA. The statute does not allow nominal damages, speculative losses, or compensation for subjective feelings of disappointment. The phrase actual damages in the FDUTPA context is a term of art. And there's case law. The sole permissible measure. I can't even. Hold on, I need to take a drink. You guys still with me?
Oh, I'm
Yeah.
I'm still there.
The sole permissible measure of actual damages is the difference in market value of the product or service in the condition in which it was delivered and its market value in the condition in which it should have been delivered according to the contract of the parties. This is so crazy because this just doesn't even exist here, But anyway, the phrase actual damages for FDUTPA purposes does not include consequential damages or lost profits. Dismissal of an FDUTPA claim is warranted if the complaint fails to plausibly allege actual damage of FDUTPA because the plaintiff has not pled the plausible claim for actual damages under the FT. Okay, that was affirming dismissal of the FDUTPA because the plaintiff has not pled plausible damage. Okay, I got that. Okay. So, looking to plaintiff's second amended complaint, it fails to plausibly allege actual damages caused by defendant Lee's violation of the FDUTPA. Indeed, plaintiff's claims are ill-suited to the requirements of the FDUTPA because this case does not involve a product or service, much less the delivery of that product or service in a manner that was not contemplated under a contract. Very good.
Isn't that what you've been saying since the beginning?
Yes. Yes. Thus, the allegations in the second amended complaint provide no basis for determining that actual damages, as that phrase has been interpreted for FDUTPA purposes, were caused by defendant Lee's alleged conduct. The second amended complaint simply states in conclusory fashion that defendant Lee's deceptive and unfair trade practices caused plaintiffs to suffer actual damages. But such conclusory allegations are insufficient to state a plausible FDUTPA damages claim. Plaintiffs claim that they are entitled to $959,000 in damages for the alleged FDUTPA violation, but the second amended complaint fails to explain how that amount constituted the difference in the market value of the product or service in the condition in which it was delivered and its market value in the condition in which it should have been delivered according to the contract of the parties. Accordingly, the FDUTPA damages claim against defendant Lee in count 2 should be dismissed. Thank you! Similarly, plaintiffs' request for injunctive relief under the FDUTPA should be dismissed. In the FDUTPA context, injunctive relief is not a standalone cause of action. And then it says case law. Rather, it is a remedy for a violation of FDUTPA. To state a claim for injunctive relief under FDUTPA, a plaintiff must allege 1, a deceptive or unfair act or practice in trade, and 2, that plaintiff is a person aggrieved by the deceptive act or practice, and 3, looking for the first requirement. An act is not deceptive and a practice is not unfair unless the consumer was actually aggrieved by the act or practice. Although a non-consumer may assert an FDUTPA claim, the plaintiff must allege that the relevant act or practice was harmful to a consumer. Here, plaintiffs have failed to plausibly allege that a consumer was actually aggrieved by a deceptive or unfair practice committed by defendant Lee. The allegations in the second amended complaint are about conduct by defendant Lee that was allegedly injurious to plaintiffs, not to consumers. FDUTPA claim because the allegations were about conduct allegedly committed against the non-consumer plaintiff. Did he say that? The non-consumer plaintiff? Sorry. Not the unfair practices committed against consumers, emphasis in original. Although plaintiffs have stated the conclusion that a consumer was aggrieved. Labels and conclusions and a formulaic recitation of the elements of a cause of action will not do. And then case law again. At the end of the day, the FDUTPA is a consumer protection statute that was designed to protect consumers from unfair and deceptive trade practices. It is clear to the court that the allegations in the second amended complaint are not aimed at vindicating consumers who were harmed by defendant Lee's conduct. Because plaintiffs have not plausibly alleged an FDUTPA claim, the claim for injunctive relief against defendant Lee should be dismissed. Are we with me?
Yeah. Well,
Still
listen,
watching.
keep reading.
All right. Give me a second. I need to take a breather. So how are we doing so far?
Great.
Got
Why don't
a
we have,
big smile on my
Great.
face.
I'm kind
Why
of
don't we
upset
have-
though.
Why don't
Why?
you have Rich read
I
some
want to
of
get
it?
to Richard's part where they can't dismiss Richards. Jeremy already agreed to trial by combat. Damn it!
Well, that's the point. I might they might order me to have a duel with him. That's what we do.
We need that.
Let Richard read his.
Well, you want me to read it a little bit?
Yeah, sure. If you want to, go for it.
I'll do a little bit. I got like 5 minutes, and I got to run back and get my dinner on the table, and I'll be right back after that. But Lanham Act. In count 3 of the second amended complaint, plaintiffs claim that defendant Lee violated sections 32 and 43A of the Lanham Act, 15 U.S.C. 1125A, and all that other fun stuff. The Lanham Act was intended to make actionable the deceptive and misleading use of marks and to protect persons engaged in commerce against unfair competition. DASTAR and other stuff. The Lanham Act contains numerous causes of action. Because of that, a plaintiff who asserts a claim pursuant to 1125 must specify the type of claim he seeks to assert. In the second amendment complaint, plaintiffs specify that defendant Lee violated section 43A of the Lanham Act and violated section 32 of the Lanham Act. Section 43A forbids unfair trade practices involving infringement of trade dress, service marks, or trademarks, even in the absence of federal trademark registration. To prevail on a claim under 1125A1A, a plaintiff must show, 1, that it had prior rights to the mark at issue, and 2, the defendant had adopted a mark or name that was the same or confusingly similar to its mark, such that consumers are likely to confuse the two. Satisfying the first element requires proof of a valid trademark.
I lost you.
Plaintiff need not have a registered mark. Instead, the 11th Circuit has said that the use of another's unregistered common law trademark can constitute a violation of 43A, where the alleged unregistered marks used by the plaintiff are so associated with its goods. The use of the same or similar marks by another company constitutes a false representation that its goods came from the same source. Looking to the allegations in the second amended complaint, plaintiffs have failed to plausibly allege either element of a claim under 1125A1A. Plaintiffs have not plausibly alleged they had prior rights to any trademark, registered or common law. Indeed, the second amendment complaint's factual allegations say nothing about plaintiffs having a trademark. Thus, plaintiffs have not plausibly alleged facts sufficient to establish the first element of a claim under 1125A1A. They have also not plausibly established facts sufficient to establish the second element of a claim under 1125A1A. More specifically, the allegation in the second amended complaint failed to plausibly allege that defendant Lee, quote, adopted a mark or name that was the same or confusingly similar to plaintiff's mark, such that consumers were likely to confuse the two. The second element of a claim under 1125A1A is all about showing a likelihood of consumer confusion between the plaintiff's mark and the mark used by the defendant. Here, there are no factual allegations from which the court could reasonably infer that defendant Lee has a mark, registered or otherwise. Even if there were such factual allegations, there is nothing in the second amendment complaint that could lead the court to draw the reasonable inference that defendant Lee employed marks that were similar enough to plaintiffs to create a likelihood of confusion. Accordingly, the plaintiffs have failed to state a plausible claim that defendant Lee violated section 43A of the Lanham Act, as alleged in the second amended complaint. The same is true with respect to the plaintiff's claim that defendant Lee willfully violated section 32 of the Lanham Act. First, the court would note that section 32 of the Lanham Act is not codified. It's not codified at 15 U.S.C. 1125A as stated in the second amended complaint. Instead, section 32 is actually codified at 15 U.S.C. 1114. Recognizing that the Lanham Act was codified at 11.4, so the court assumes the plaintiff meant to cite 15 U.S.C. 1114 instead of 15 U.S.C. 1125 when referring to the alleged violation of the Lanham Act. That's basically, Shaka doesn't know the difference between the rules. To succeed on a claim under 15 U.S.C. 1114, plaintiff must demonstrate that the mark, 1, that its mark has priority, and 2, the defendant's mark is likely to cause consumer confusion. Unlike a claim under USC 1125A, a claim under 15 USC 1114 requires the plaintiff to have a federally registered trademark.
Read footnote 6.
This argument makes plaintiff's second amended complaint a shotgun pleading because plaintiffs are asserting two separate legal claims in the same count. A claim under 15 USC 1125A and a claim under 15 USC 1114. But nonetheless, the court will prefer to resolve this dispute on the merits instead of a shotgun pleading ground.
Wow.
Turning to the allegations in the second amended complaint, plaintiffs have not alleged that they have registered a trademark with the U.S. Patent and Trademark Office. That is fatal to their claim that the defendant violated Section 32 of the Lanham Act. Right? Even if plaintiffs had alleged that they had a federally registered trademark, the claim would still be subject to dismissal because the second amended complaint fails to plausibly allege a likelihood of confusion. A claim under 1114 requires the use of a trademark in commerce that is likely to cause confusion. Liability for a violation turns on whether the junior user's mark is likely to cause confusion on the senior user's mark. The second amended complaint fails to plausibly allege that defendant Lee used a mark that caused a likelihood of confusion with a registered mark belonging to plaintiffs. Thus, plaintiffs, Jeremy Hales, have failed to state a claim against defendant Lee under 15 U.S.C. 1114. There's one more thing to discuss, at least briefly, regarding count 3. In the second amendment complaint, the title of count 3 references false advertising. But neither of the statutory provisions, 1114 and 1125A1A, that plaintiffs say that defendant Lee violated in the body of count 3, deal with false advertising. Plaintiffs are represented by counsel. This court need not liberally construe the complaint as it does for pro se litigants. Moreover, it is not this court's role to rewrite a deficient complaint or to guess about what the plaintiff, especially a represented one, intended to bring. Thus, the court
that's shade on Shockett, isn't it?
Yes, Shockett. This is a botched abortion on his part. Thus, the court need not address whether plaintiff had plausibly alleged a false advertising claim because the second amendment complaint does not actually assert such a claim. Instead, it asserts defendant Lee violated 15 U.S.C. 1114 and 1125A1A, neither of which address false advertising. Nonetheless, to the extent plaintiffs intended to bring a claim of false advertising under revision of Lanham Act, they have not cited such a claim would be subject to dismissal. To succeed on a false advertising claim, 15 U.S.C. 1125A1B, plaintiff must establish the advertisements of the opposing party are false or misleading, advertisements deceived or have the capacity to deceive consumers, the deception had a material effect on purchasing decisions, the misrepresented product or service affects state commerce, and the movement has been or is likely to be injured as a result of the false advertising. Here, plaintiffs have not plausibly alleged defendant Lee used false and misleading advertising that deceived or had the capacity to deceive consumers. Unlike advertisements, the statements allegedly made by defendant Lee on YouTube and other social media outlets did not propose a commercial transaction. That's pretty big. Keep going. Instead, what defendant Lee is alleged to have done would be better described as communicating information, expressing opinion, and reciting grievances. The fact that defendant Lee may have solicited donations or offered premium subscriptions on a YouTube page does not give rise to a cause of action for false advertising under the Lanham Act.
Thank you. Thank you.
Keep going. Keep going. Next page.
I just keep saying, wow. I just can't.
Count 3.
Hold on. Do you think at this point in the game, no, seriously, like, do you think at this point that Bolitho has read everything that we've sent him now?
Absolutely.
He's seen it all. He's seen it all. He's, I think the guy's a pretty good judge at this point. Really, no, I really do. So you've seen this so far. He's pretty good.
Yeah, so far reading this, you're like, wow, because we did not.
Somebody take over for me. I got to make sure the chicken's out of the oven. I'll be right back. I got to get another beer.
Dave,
where are we even at? The fact that defendant Lee? No, hold on. The fact that defendant Lee may have solicited donations or offered premium subscriptions on her YouTube page does not give rise to a cause of action for false advertising under the Lanham Act. And see the case law on that. The ability. Should we just go to commercial advertising for Lanham Act purposes? 3, tortious interference. In count 4, plaintiffs have alleged defendant Lee tortiously interfered with business relationships. Under Florida law, the elements of tortious interference with a business relationship are A, 1, the existence of a business relationship that affords the plaintiff existing or prospective legal rights. 2, the defendant knowledge of the business relationship. 3, the defendant's intentional and unjustified interference with the relationship. And 4, damage to the plaintiff. Should we read the...
Yeah,
read
it.
Any doubt about whether plaintiff has started plausible claim under the Lanham Act can be resolved by considering the purposes of the Lanham Act. The act was designed to, 1, make actionable the deceptive and misleading use of marks in interstate commerce. 2, to protect registered marks used in commerce from interference by state or territorial legislation. 3, to protect persons engaged in such commerce from unfair competition. 4, to prevent fraud and deception in such commerce by the use of reproductions, copies, counterfeits, or colorable imitations of registered marks. And 5, to provide rights and remedies stipulated by treaties and conventions respecting trademarks, trade names, and unfair competition entered into between the United States and foreign nations. The allegations against defendant Lee in this case in no way seek to vindicate the listed purposes of the Lanham Act.
Nice. All right. So, but we already went into the tortious interference part. So that I guess we missed the footnote up there somewhere. All right. So go ahead. Here, the second amended complaint.
Yeah. Here, the second amended complaint alleges that plaintiffs had a business relationship with YouTube and whatnot, as well as other companies. Make sure you notice that that's in quotes, other companies, as unspecified quote-unquote customers. There's no cause of action for tortious interference with business relationships to community at large. Additionally, a tortious interference claim requires the plaintiff to show a business relationship with identifiable customers. Plaintiff's second amended complaint does not identify any customers. It simply generically refers to quote-unquote customers. That is insufficient to state a claim at the same and the same is true with regard to the plaintiff's allegations involving their business relationships with other unidentified companies. Dismissing tortious interference claim because allegations that the defendant interfered with sales to various customers was too vague and abstract to satisfy the first element of a tortious interference claim. And there's some case law on that. When pleading the existence of a business relationship, plaintiffs must identify in their complaint the customers or clients that are subject of a defendant's alleged interference. As for allegations regarding YouTube and whatnot, plaintiffs have alleged existing and specific business relationships. So the first element of tortious interference has been plausibly alleged, and the court will assume that plaintiff's general statement about defendant Lee's knowledge of those business relationships is sufficient to satisfy the second element. See this case law here, finding that the defendant's knowledge of a business relationship need not be pleaded with specificity. That leads to the third element, which is where plaintiffs have a problem because they have not plausibly alleged that defendant Lee intentionally and unjustifiably interfered with plaintiffs' business relationships with YouTube and or whatnot. Although there are allegations that defendant Lee posted content about plaintiffs on her own YouTube channel, plaintiffs have not plausibly alleged that defendant Lee contacted YouTube or whatnot representatives or otherwise did anything to interfere with the business relationship that plaintiffs had with YouTube and whatnot. There's some case law on that, affirming dismissal where there is no allegations that the defendant conveyed the information in question to the entity which the plaintiff had business relationship. Nor is there any allegation that the business of defendant Lee's conduct, YouTube or whatnot, terminated or otherwise altered their business relationships with plaintiffs. Thus, plaintiffs have failed to plausibly allege their third element of tortious interference with a business relationship claim.
Yes. You guys realize what this means, okay? You got to remember, in order for everybody else to be in conspiracy, right? You have to have two torts, and the two torts is the Lanham Act and the what's it called? The FDU, CPA, whatever.
FDUPTA.
So they have to have those, two things in order to even prove conspiracy with everybody else. And basically, it's been knocked out right out of the park, including.
Can I just say one? Can I just say one thing? How much is Jeremy in debt with this lawyer again? Can somebody in the chat read
$7,000?
And he's batting 0 for how many now?
Yeah, I just got someone just said go look at Tug's thumbnail for tonight, and if you look at it, there's 77 people waiting right now, and it says Preston loses big with question marks. Says Jeremy Hales wins in court. Are you kidding me? How they? We're not even halfway through this damn thing, and that there's somehow a win here. I don't. Let's keep going, Dave.
Plaintiffs have also failed to plausibly plausibly allege that the last element damages are an essential element of a tortious interference claim. There's some more case law. Thus, dismissal is warranted if a plaintiff fails to plausibly allege damages suffered as a result of the breach of the business relationship. This means that the plaintiff must connect the loss of the business relationship to the alleged tortious conduct of the defendant. Here, plaintiffs seek a whopping $1,835,000 in damages for defendant Lee's tortious interference. But the allegations in the second amended complaint fail to plausibly connect defendant Lee's supposed tortious interference to the breach or loss of any business relationship with YouTube or whatnot. Nor does the second amended complaint allege the value of any such business relationship that was lost or breached as a result of defendant Lee's conduct. Thus, plaintiffs have failed to plausibly allege the fourth element of tortious interference claim. Because plaintiffs have failed to plausibly allege several elements of a tortious interference with a business relationship claim, count 4 should be dismissed.
Thank you. Here we go.
Then we go to the civil conspiracy, and this is the one that involves most of us.
Right.
In count 6, plaintiffs claim defendant Lee engaged in a civil conspiracy. Under Florida law, the elements of a civil conspiracy are A, an agreement between two or more parties, B, to do an unlawful act or to do a lawful act by unlawful means. C, the doing of some overt act in pursuance of the conspiracy, and D, damage to the plaintiff as a result of said acts done under the conspiracy. The gravamen of the civil conspiracy claim in Florida is the underlying tort carried out by virtue of the conspiracy, not the conspiratorial agreement itself. This means that if there is no actionable underlying tort, a civil conspiracy claim will fail.
Ding, ding, ding. What did I just say?
And then there's case law on that. An actionable conspiracy requires an actionable underlying tort or wrong. According to the second amended complaint, defendant Lee is alleged to have conspired with others to violate the FDUPTA, the Lanham Act. You never heard it called FDUPTA?
I know, but I just have the FTU did it, whatever.
Yeah. The Lanham Act and to tortiously interfere with business relationships. As explained above, those claims are subject to dismissal for failure to state a plausible claim. And because the underlying claims fail, the civil conspiracy claim necessarily fails.
Exactly.
There's case law on that.
Ding, 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 ding.
Stating that because the underlying claims do not survive this motion to dismiss, they cannot substantiate plaintiff's civil conspiracy claim. Mm-hmm. And then there's some case law on that. Because the underlying breach of contract of FDUPTA claims fail, so must the civil conspiracy claim. Accordingly, the civil conspiracy claim against defendant Lee in count 6 must be dismissed. And then it goes on to each one of us. And it basically...
But it does have a footnote there. It does have a footnote there.
Yeah, especially when it came to me, they basically... Go ahead.
Super Dave, read my name. Does it say must be dismissed?
It does. I believe it does. And it's in the footnote on mine, it said that repleading would be a futile effort because they've already had several times to change this and they haven't. So those are some interesting footnotes. But you want me to read this footnote?
I know. I thought we were just going to read the whole thing for everybody.
Oh, sure. Sure. We can. Sure.
You know,
So we're on Defendant Matskin's motion to dismiss. Having resolved Defendant Lee's motion to dismiss, the court will now turn to Defendant Matskin's motion to dismiss. And there's a footnote there. Even if the second amended complaint, do you want me to read that footnote or no?
No, it's all right. You already passed it. It's
okay.
good.
Amended complaint alleges Defendant Matskin tortiously interfered with plaintiff's business relationships, count 5, and also participated in a civil conspiracy, count 7. 1. Tortious interference. The law regarding what is necessary to state a claim for tortious interference is set forth above and will not be repeated here. The second amended complaint alleges that Defendant Matskin tortiously interfered with plaintiff's contracts and advantageous business relationships with its customers and other companies, including, without limitation, Whatnot Incorporated and YouTube. Document 76 and at 54. Defendant Matskin argues that plaintiff's allegations are insufficient to state a plausible tortious interference claim. The court agrees with Defendant Matskin.
Wow,
First, as explained above.
I'm sorry, wait. Can I just do this?
Yeah.
And the reason why I'm doing this is, there you go, Bruce. I just wanted to see Bolitho's wordings. You know what I mean? The court agrees with Defendant Matskin. You know, after all this, I just wanted to highlight that right there. You know? Go ahead.
As explained above, with regards to Defendant Lee, a tortious interference claim requires the plaintiff to show a business relationship with identifiable customers. Here, plaintiff's second amended complaint does not identify any customers. It simply generically refers to customers. That is insufficient to state a claim. The same is true with regard to plaintiff's allegations involving the business relationship with other unidentified companies. Dismissing the tortious interference claim because allegation with the defendant interfered with sales to various customers was too vague and abstract to satisfy the first element of a tortious interference claim. And there's some case law on that. When pleading the existence of a business relationship, plaintiffs must, with specificity, say that word for me. Yeah, there. Sorry, one of them days. Specifically identify with their complaint that the customers or clients that are the subject of defendant's alleged interference. Thus, plaintiffs have failed to plausibly allege that Defendant Matskin tortiously interfered with plaintiff's business relationships with its unspecified customers and unidentified companies. Regarding the allegations involving Whatnot and YouTube, plaintiff has alleged existing and specific business relationships. So the first element of tortious interference has been plausibly alleged, and plaintiffs have plausibly alleged that Defendant Matskin had knowledge of those business relationships. That leads us to the third element, which is again where plaintiffs have a problem, because the second amended complaint fails to plausibly allege that Defendant Matskin intentionally and unjustifiably interfered with plaintiff's business relationships with YouTube and or Whatnot. Although there are allegations that Defendant Matskin posted content about plaintiff Hales on YouTube, plaintiffs have not plausibly alleged that Defendant Matskin contacted YouTube representatives or otherwise did anything to interfere with the business relationship that plaintiffs allegedly had with YouTube. Case law on that, and that's affirming dismissal where there is no allegation that the defendant conveyed the information in question to the entity with which the plaintiff has had a business relationship. As for Whatnot, plaintiffs have alleged that Defendant Matskin had contact with a Whatnot representative during an email exchange regarding discovery in one of the other cases plaintiff Hales has filed. But plaintiffs have failed to plausibly allege that the contact with a Whatnot representative actually interfered with a plaintiff's business relationship with Whatnot. More specifically, there are no allegations that Whatnot terminated its contact with plaintiffs, denied plaintiffs access to Whatnot platform, or otherwise altered plaintiff's business relationship with Whatnot. As a result, Defendant Matskin's conduct, alleged interference and failure of the agreement precludes recovery as a matter of law. Thus, plaintiffs have failed to plausibly allege that the third element of a tortious interference with a business relationship played regarding Whatnot. Plaintiffs have also failed to plausibly allege that the last element damages are an essential element of a tortious interference claim. Case law, thus dismissal is warranted if a plaintiff fails to plausibly allege damages suffered as a result of the breach of the business relationship. This means that the plaintiff must connect the loss of the business relationship to the alleged tortious conduct of the defendant. Here, plaintiffs seek a whopping $1,229,000 in damages for defendant Matskin's tortious interference. And that's at Doc 76 at 53. But the allegations in the second amended complaint fail to plausibly connect defendant Matskin's supposed tortious interference to the breach of any contract or loss of any business relationship. Nor does the second amended complaint allege the value of any such breach contract or lost business relationship that resulted from defendant Matskin's conduct. Thus, plaintiffs have failed to plausibly allege the fourth element of a tortious interference claim because plaintiffs have failed to plausibly allege several elements of a tortious interference with the business relationships claim. Count 5 should be dismissed. All right, I'm going to pass on that.
All right, who's going next? Anybody?
I'm working in the hot room, so.
Do we still have everybody here? We lost Tammy.
I'm still here, but
all right.
I don't want to get on there.
I'll do all right. So civil conspiracy. In count 7, plaintiffs claim defendant Matskin is liable for civil conspiracy. That claim fails for the same reasons discussed above regarding plaintiff's civil conspiracy claim against defendant Lee. Accordingly, count 7 should be dismissed. Defendant Cook's motion to dismiss. In count 9, plaintiffs claim defendant Cook is liable for civil conspiracy. Defendant Cook has moved to dismiss for failure to state a claim. The civil conspiracy claim against defendant Cook fails for the same reasons discussed above regarding plaintiff's civil conspiracy claim against defendant Lee. Accordingly, count 9 should be dismissed. Defendant Hughes, Marla. In count 10, say that again?
I said it was short and sweet.
Yeah. Marla, defendant Hughes motion to dismiss. In count 10, plaintiffs claim defendant Hughes is liable for civil conspiracy. Defendant Hughes has moved to dismiss for failure to state a claim. The civil conspiracy claim against defendant Hughes fails for the same reasons discussed above regarding plaintiff's civil conspiracy claim against defendant Lee. Accordingly, count 10 should be dismissed. Defendant Bonebreak. Motion to dismiss. Count 14. Plaintiffs claim defendant Bonebreak is liable for civil conspiracy. I'm sorry. Hold on a second. So sorry.
That was me. That was just me not too long ago.
Defendant Bonebreak has moved to dismiss for failure to state a claim. The civil conspiracy claim against defendant Bonebreak fails for the same reasons discussed above regarding plaintiff's civil conspiracy claim against defendant Lee. Accordingly, count 14 should be dismissed.
Thank you.
Yeah.
Defendant Kesey's motion to dismiss. In count 12, plaintiff claims defendant Kesey is liable for a civil conspiracy. Defendant Kesey has moved to dismiss for failure to state a claim. The civil conspiracy claim against defendant Kesey fails for the same reasons discussed above regarding plaintiff's civil conspiracy claim against defendant Lee. Accordingly, count 12 should be dismissed. And there is Number 9, footnote 9. Defendant Bonebreak's name is Raymond G. Bonebreak Jr. The second amended complaint refers to him as defendant Raymond. Okay.
And though the trolls that are listening to this and they're still siding with Jeremy, shame on you.
Yeah. Defendant Helms motion to dismiss. In count 11, plaintiffs claim defendant Helm is liable for civil conspiracy. Defendant Helm has moved to dismiss for failure to state a claim. The civil conspiracy claim against defendant Helm fails for the same reasons discussed above regarding plaintiff's civil conspiracy claim against defendant Lee. Accordingly, count 11 should be dismissed. Aside from seeking dismissal, defendant Helm seeks to recover his attorney fees under Florida's anti-SLAPP statute. Florida's anti-SLAPP statute prohibits a person from filing a cause of action against another person or entity without merit, and primarily because such a person or entity has exercised the constitutional right of free speech in connection with a public issue. It further provides that a court shall award the prevailing party reasonable attorney fees and court costs incurred in connection with the claim that an action was filed in violation of this section.
I guess MLS is in chat.
What?
I guess MLS is in chat.
Oh, really? What's up, MLS? According to defendant Helm, the anti-SLAPP statute entitles him to reasonable attorney fees because plaintiff's allegations are without merit, and this lawsuit was commenced because defendant Helm exercised his right to free speech by appearing on YouTube broadcasts to discuss plaintiff Hales and another lawsuit plaintiff Hales had filed. In response to defendant Helm's motion to dismiss, plaintiffs have argued that their claim against defendant Helm has merit and that defendant Helm's speech was commercial speech that is not covered by the anti-SLAPP statute. Defendant Helm has met the anti-SLAPP statute's first requirement because, as explained above, plaintiff's claim against him lacks merit. Turning to the anti-SLAPP statute's second requirement, a claim must have been brought primarily because defendant Helm has exercised the constitutional right of free speech in connection with a public issue. The anti-SLAPP statute defines free speech in connection with public issues as any written or oral statement that is protected under applicable law and is made before a governmental entity in connection with an issue under consideration or review by a governmental entity, or is made in or in connection with a play, movie, television program, radio broadcast, audiovisual work, book, magazine, article, musical work, news report, or other similar work. This is the Florida statute. There, free speech made in connection with public issues is, in pertinent part, merely requires a showing that the public speech is contained in or was made in connection with one of the listed media formats or other similar modes for widely disseminating protected First Amendment speech. Here, the allegations in the Second Amendment complaint involve oral and written statements made by defendant Helm that were protected under applicable law. The oral statements were made as part defendant Helm's operation of a YouTube channel called Making Law Simple, and the written statements were made in connection with a YouTube broadcast that was being conducted by defendant Lee on her YouTube channel. These YouTube broadcasts are audiovisual works or similar works, and in the current world, YouTube is undoubtedly an other similar mode for widely disseminating protected First Amendment speech. Thus, the requirements of Florida's anti-SLAPP statute have been met. In an attempt to avoid this conclusion, plaintiffs argue in cursory fashion that the anti-SLAPP law does not apply because the lawsuit was aimed at defendant Helm's unlawful conduct, which includes but is not limited to actionable commercial speech. Plaintiffs' argument that the allegations against defendant Helm are based on conduct and not speech is incorrect. The gravamen of plaintiff's actions, did I say that right? Gravamen?
I always ask that too.
Yeah. The gravamen of plaintiff's actions against defendant Helm are things he said and wrote. In other words, his speech. And that speech was not unprotected commercial speech. Even if it was commercial speech, that would not mean it was unprotected speech. Recognizing that commercial speech is accorded a measure of First Amendment protection, but that protection is more limited than the protection afforded to non-commercial speech. Okay, the core notion of commercial speech is speech which does no more than propose a commercial transaction. In this case law, our commercial speech doctrine rests heavily on the common sense distinction between speech proposing a commercial transaction and other varieties of speech. Cleaned up. Here, defendant Helm's speech did not propose a commercial transaction. Rather, defendant Helm's speech consisted of a commentary and criticism regarding plaintiff Hales. As such, it was a written or oral statement that is protected under applicable law. By the way, guys, this goes for all of us.
Yes.
What he's saying here, okay? And within the definition of free speech in connection with a public issue for purposes of Florida's anti-SLAPP statute. Because plaintiff's claim against defendant Helm is without merit and was filed primarily because he exercised and the constitutional right of free speech in connection with a public issue, plaintiffs should be required to reimburse defendant Helm for his reasonable attorney fees and costs in defending against this lawsuit under Florida's anti-SLAPP statute. Nice! Nice, very nice.
Well, I didn't read that part.
Yeah. Okay, defendant Teschendorf's motion to dismiss. In count 13, plaintiffs claim defendant Teschendorf is liable for civil conspiracy. Defendant Teschendorf has moved to dismiss. Defendant Teschendorf, a non-Florida resident, asserts that dismissal is warranted under Rule 12b-2 for lack of personal jurisdiction. He has also sought dismissal for failure to state a claim under Rule 12b-6. The court will first address the jurisdictional argument and then move to the failure to state a claim argument.
Yeah, he broke it down smooth for me, so I understood this perfectly. He's right.
As a general rule, courts should address issues relating to personal jurisdiction before reaching the merits of plaintiff's claims. Okay. So personal jurisdiction. A federal district court in Florida may exercise personal jurisdiction over a non-resident defendant to the same extent that a Florida court may, so long as the exercise is consistent with federal due process requirements. Under Florida's long-arm statute, jurisdiction exists over the non-resident defendant who commits a tort outside of the state that causes injury inside the state. Plaintiffs allege that defendant Teschendorf operated a YouTube channel and made comments on that YouTube channel that caused harm to plaintiffs in Florida. Isn't that so strange that his main residence is... Oh, sorry, Tammy, I just saw you. His main residence is Ohio, and he keeps saying Florida, Florida. He just tried to...
But sometimes it's vacation home. I get confused by that, you know.
Okay. Those YouTube comments involve statements allegedly made by defendant Teschendorf regarding plaintiff Hales' conduct during litigation in a separate Florida lawsuit involving Hales and neighbors from Florida, i.e. defendants Preston and Cook. Definitely reading it. Definitely read it all. That is sufficient for personal jurisdiction under Florida's long-arm statute. And in this case law, finding Florida's long-arm statute reached the out-of-state creator of a website because the website was accessed in Florida and allegedly caused harm in Florida. Okay. Case law here. Finding that Florida's long-arm statute reached out-of-state website conduct because the website allegedly caused injury in Florida. All right. Having found that the Florida's long-arm statute confers jurisdiction over defendant Teschendorf, it is necessary to address whether the due process clause of the U.S. Constitution permits the exercise of jurisdiction. Under the due process clause, jurisdiction may not be exercised over a non-resident defendant unless his contact with the state is such that he has fair warning that he may be subject to suit there. The constitutional litmus test for personal jurisdiction is whether the defendant purposely established minimum contacts in the forum state. In intentional tort cases like the current one, the 11th Circuit has applied the Calder effects test. Calder, okay, so that's case law. To determine whether there have been sufficient minimum contacts.
Culver, you're making me hungry.
I said Calder, not Culver.
Oh, Culver. That's great.
I love some Culvers.
Under this test, a non-resident defendant's single tortious act can establish purposeful availment without regard to whether the defendant had any other contacts with the forum state. The effects test is met with when tortious behavior is intentional, aimed at the forum state, and caused harm that the defendant should have anticipated would be suffered in forum state. Here, the court finds that the plaintiffs have satisfied the Calder effects test. Plaintiffs have alleged that defendant Teschendorf's conduct was intentional, and they have alleged that defendant Teschendorf's conduct was aimed at Florida. His YouTube channel was accessible in Florida, and he allegedly used his YouTube channel to make comments about plaintiff Hales' actions in another Florida lawsuit, and plaintiff Hales' conduct in an ongoing saga involving a neighboring property owner in Florida. Under the circumstances at issue here, defendant Teschendorf should have anticipated that any harm caused to plaintiffs would be suffered in Florida. Accordingly, defendant Teschendorf had sufficient minimum contacts with the forum state to satisfy due process. Finally, thank you. Finally, the court must consider whether the exercise of a personal jurisdiction over defendant Teschendorf would comport with fair play and substantial justice.
Something I should have raised.
Yeah. So let's see. Relevant factors include the burden on the defendant, the forum's interest in adjudicating the dispute, the plaintiff's interest in obtaining convenient and effective relief, and the judicial system's interest in resolving the dispute. Defendant Teschendorf has not offered any evidence of his finances or any other limitations on him to show that he would be burdened by having to litigate the case in Florida. And it shows case law there. Moreover, the allegations in this case are highly Florida-centric, which provides Florida with a strong interest in hearing the case. Finally, plaintiffs have an interest in having this case resolved in Florida. The court, therefore, finds that exercising What? Somebody say something?
Nothing. Hey, I said I'm gonna
what?
I'm gonna jump in and feed the snakes. I got deadly snakes I got to do. So I'll jump back in after.
Okay.
Have fun.
All right. Bye.
Have fun.
Always, buddy. Always. I'm doing the jig while I'm cleaning cages.
I was just gonna say, at least you got a smile on your face.
Right?
You have no idea. Just to see how this just proves this guy's such a liar and piece of shit.
Okay, so finally, plaintiffs have an interest in having the case resolved in Florida. The court therefore finds that exercising personal jurisdiction over defendant Teschendorf would comport with fair play and substantial justice. Failure to state a claim. Yep, I have to agree with that, I guess.
Yeah.
Failure to state a claim. The court will now turn to defendant Teschendorf's argument that the civil conspiracy claim against him in count 13 should be dismissed for failure to state a claim. With regard to that issue, the court finds that the civil conspiracy claim against defendant Teschendorf fails for the same reasons discussed above regarding plaintiff's civil conspiracy claim against defendant Lee. Accordingly, count 13 should be dismissed. Defendant Teschendorf also seeks reasonable attorney fees under Florida's anti-SLAPP statute.
Hey, I just want to say if it applied, because I wasn't sure if I was going to hire an attorney yet or not. So I just want to, not like I'm trying to penny pinch and pull anything I can out of.
You didn't know. You didn't know if you were going to need the attorney. Yeah. None of us did who don't have one. So, but defendant Teschendorf is not entitled to such fees because he's proceeding pro se. So we got that. Okay. So. What was the other part? There's no basis for providing plaintiffs with another opportunity to amend. Plaintiffs were previously given an opportunity to amend after defendant Helm filed a motion for more definitive statement. That's correct. Plaintiffs are represented by counsel, and the 11th Circuit Court has never required district courts to grant counsel's plaintiff more than... What is that? Whoa. Is that still...
Keep going. That's a one-page footnote. Keep going to 44.
Okay. All right, so defendant Hughes. Wait a minute, hold on. I skipped something.
Oh, more than
Okay. So, so conclusion. For the reasons above, it is respectfully recommended that 1. Defendant Helm's motion to dismiss be granted, and the claims against defendant Helm dismissed with prejudice. 13 for failure to state a claim. Okay. Keep going. 2. Defendant Hughes' motion to dismiss be granted, and the claims against defendant Hughes dismissed with prejudice for failure to state a claim. 3. Defendant Matskin's motion to dismiss be granted, and the claims against defendant Matskin's dismissed with prejudice for failure to state a claim. Defendant Cook's motion to dismiss be granted, and the claims against defendant Cook dismissed with prejudice for failure to state a claim. Defendant Lee's motion to dismiss be granted, and the claims against defendant Lee dismissed with prejudice for failure to state a claim. Defendant Bonebreak's motion to dismiss be granted, and the claims against defendant Bonebreak dismissed with prejudice for failure to state a claim. Defendant Kezi's motion to dismiss be granted, with the claims against defendant Kezi dismissed with prejudice for failure to state a claim. Defendant Teschendorf's motion to dismiss be granted, and the claims against defendant Teschendorf dismissed with prejudice for failure to state a claim. And this matter be committed to the undersigned for further proceedings involving defendant Preston and Luthman, as well as the determination of the reasonable attorney fees due to defendant Helm under the Florida's anti-SLAPP statute at Pensacola, Florida, this 10th day of February 2026. 14, as stated previously, hold on, let me, why can't, it won't go down anymore. There we go. Hold on. Uh-oh. Let me go back. It wouldn't move. It won't move anymore. As stated previously, this stayed as defendant Preston because of her pending bankruptcy. With regard to defendant Luthman, the issues raised recently became ripe and remained under consideration by the undersigned. Became ripe, Richard. Notice to the parties. Objections to these proposed findings and recommendations must be filed within 14 days of the date of the report and recommendation. Any different deadline that may appear on the electronic docket is for the court's internal use only and does not control. An objecting party must serve a copy of the objections on all other parties. A party who fails to object to the magistrate judge's findings or recommendations contained in a report and recommendation waives the right to challenge on appeal the district court's order based on unobjected to factual and legal conclusions. Wow.
So let it be written. So let it be done.
Wow. So, Richard, what happens from here?
Basically, he's going to object to this whole thing. I can guess from sitting here. Shockett's going to file the Rule 72 objections. It's going to go to Hinkle. Hinkle's going to confirm the report of Bolitho. And then there's also going to be potentially additional reports on Preston and on myself on our motions, basically given what's going on. And then the court is going to be ruling on all that stuff. So I have different issues because I claimed alternative dispute resolution. The court might turn around and say, okay, you can go have your trial by combat. Or the court could say there's no trial, or the court could say that Luthman was never served. They might even do with the service part and say he wasn't properly served. This is, it's over from that perspective. So they'll dismiss it. But we'll see. We'll see what happens. I don't think they want to get to the trial by combat issues with me. I really don't think. I think they just want to say he wasn't served. So adios.
Richard, are you aware that your trial by combat stunt you did a few years ago, that has actually started a trend with people in litigation? Are you aware of that?
I know people copied me. There are a lot of copycats out there.
Yeah, sure are. I just noticed that the other day. I was like, man, this is something that I think Luthman started.
Yeah, I did. So it is what it is.
I'm sorry, guys, to tear up. It's been a very emotional ride dealing with all this for so long, and when you see people affected and hurt by it, and just seeing that,
over a year now. Yeah. Just about a year.
Yep. Yeah. How you feeling, Ray?
I feel a lot better. The worst part of it for me was when, things had to be submitted and my wife was in critical condition. And there was a couple weeks period in there where I didn't know where I was coming or going. And they hit me at the worst possible time in my entire life. I'm well into my 80s, and I just never faced an animal like he is. He doesn't do this for any other reason than monetary, and he throws a lot of hate in there with it.
Making money off destroying people's lives.
Yeah.
That's what he's doing.
And he stated that. And on that first charges that come my way, he was after me for saying that, talking about his money. And the channel, my video that was taken down, that was what was on it. It's part of it. And also the things he had said against the people that live in that town, what he thought about the people that worked with him. Some of it was extremely hateful, and he was putting himself up on some kind of a pedestal. And the fact that he took it down, man, he didn't want people to even hear it. He was so sure that his Sunday night lives, that nobody was listening to it. And I brought it on there and pretended like it was a interview. And it pissed him off. I never got a letter of cease and desist. All I got was a strike against my channel over it. and I was
Right.
extremely upset. And that marked the day that I decided, until I die, I will pursue that SOB. It's not over.
It's not over. It's absolutely not over. Far from it. Richard, let me. Can you explain to everybody when it says "granted"? And
does he think that like once all this thing gets dismissed, that you're just going to walk away in the sunset?
Yes. Mm-hmm. Yes, he does.
There's a lot of people are going to get surprised.
Yeah, pretty much. So, can you, Richard? Can you explain to everybody that when it says, where is it? I just want to look for the exact wording here. Granted, with prejudice. Okay, what that means when it says granted with prejudice.
So when you have, there are two things, with prejudice and without prejudice.
Mm-hmm.
And without prejudice means that he can come back and sue you again on these claims.
Right.
Okay. With prejudice means that the judge ruled on the merits of the motion and said he doesn't have a claim at all, so he can't bring this claim again. It would be stopped. It's called
Awesome.
Thank you, Lori J.
There's a bunch of things that say you can't bring this claim again. The court already said you don't have a claim, so bye-bye. Too bad, you know.
And with all these that are on here, it says with prejudice.
Hugs back.
For all of them.
It's not done until either A, 14 days expires and he doesn't object, or B, it goes to the Article 3 judge. And the Article 3 judge is going to have to put an order in place anyway that says that basically confirms the report and recommendation of Bolitho. So Hinkle's going to have to do something anyway. So we'll see what happens. I mean, I think that, but it's like, 98% at this point. There's nothing here that is even controversial.
Yeah, I don't think there's anything that Shaw could possibly say that's going to change the recommendation or, change anything.
Skyview.
I'm just glad to see that Bolitho literally read everything. Kristen, what's up?
Kristen!
Hey.
What do you guys think the spin is going to be, though, on all these channels? They're going to be running out of content now. They thought they had the next year or two supposedly booked with content.
Yeah.
So what are they going to do now? Maybe they should hop on diets and make some content.
Yeah, look, there's Tug's live right now, and it says Jeremy Hales wins in court as Preston loses big. No, nothing like that happened. Not even in the bankruptcy thing today. So, there's such bullshit going on. It's like, okay, so you want to brag over here.
Something over here.
What?
Minimize it again.
Oh, hold on.
Oh, never mind. Okay.
What? Is the wrong one?
No. I was just looking at something.
Oh. Because that's where it was. Or were you looking at those?
No, I was looking at this. Go back to it again.
Uh-huh.
Go back to, is that live?
Yeah, he's live right now.
Who's that?
That's Tug.
Oh.
What are they going to talk about now?
Yeah, that's what I'm wondering is, these channels like Squid and them, what are they going to do what's their gimmick going to be?
They're going to take each one of us and show why they think that we should have been found guilty. We've provided enough with this stuff here. They'll keep them busy for the next 3 or 4 years. They'll never let
people are going to get bored. People are going to get bored.
When their channel finally starts to fail of the subject, then they'll stop talking about it. But until then, matter of fact, if anything, they're going to see more viewers come in than less at this point right now. They are going to ride this thing till it dies.
Yeah,
not smart. It's not smart.
They're not particularly smart.
Well, the funny thing is, even when this whole case came out and all these allegations, they're reading these documents, they're reading these motions. They could care less, really, what we said, So they're not reading our points. They speculate. Megan and Tug with all their speculative bullshit, just ran off with they ran into, different tangents about everything. If they would have actually paid attention to what we were saying and the law, they would have seen exactly what Bolitho said. I know sometimes it's hard to read, but it's pretty common sense if you read what the law is and what they're accusing us of. The accusations against me, those torts, the Lanham Act and the FDUPTA, whatever.
I call it the FDUPTA.
Yeah, the FDUPTA. That was ridiculous. Absolutely 100% ridiculous. There was no proof of any of his allegations whatsoever. And, they're gonna go after. I guess Megan's not gonna want to sleep with Bolitho anymore. He should be recused and all this crap and blah blah blah. I don't care. What I really care about is that after all, Bolitho was paying attention.
I got a question. If let's just say this is locked in and it's fully dismissed and everything, does that set the plaintiff up for malicious prosecution? I'm just wondering. I don't know if it does or not. Because I seen them do that. Didn't they try doing that when Miss Preston dismissed her case and then they hit him with malicious prosecution? Wouldn't that kind of apply here? I'm just wondering.
I know. What do you think, Reds?
Say that again. What Bolitho's going to do? What?
No, I was saying, let's just say this gets locked in, by the judge as dismissed. Well, does that then set the plaintiff up for malicious prosecution from the defendants?
Oh yeah. Well, here's the point. They already set up Helm for the anti-slap because the anti-slap's in place because he filed that motion. But there could be an independent claim against Jeremy Hales if you'd like. But the problem is once it's dismissed, the case is over. You could probably still bring sanctions under the same docket number because the docket like a sanctions motion. So you can do that. You could probably bring sanctions, a sanctions motion again. But the problem is that when you're a non-represented party, the sanctions there's no attorney's fees. All the money's the attorney's fees.
True. Yeah. So just basically leave me alone. Once this is over, just leave me alone. Shit.
I think this could be like, this is getting close to, this is a second strike. He did that one strike against Dan Owen. Now he's got another strike in the Northern District with this case. He's really, starting to strike out, Yeah.
Yeah. So, is everybody going to counterclaim this guy?
I think we'll find out in the next few months.
Yep.
That's a fair statement. That's a fair statement, I'd say.
Yeah. So how long do we think it's going to take?
Years
wait
now,
14 days.
Time that he suffered a little bit too.
He'll definitely. Oh, go ahead.
Money means a lot to him, so anything that can touch his little financial empire will cause him sleepless nights. And the only thing I can say to him is, he's caused me a lot of sleepless nights. I've got a year left. Don't you think I'm going to use it?
Absolutely.
I expect an objection to be filed within a full business week, I bet. Within 7 days, I bet.
Foolish men do foolish things.
I don't think Shockett's going to let this go. I really don't. He's got to prove that he's super lawyer.
You mean like he did?
Sorry, I was just reading a bunch of messages I missed during all that. Everybody's like, "Wow, oh my god!" Like freaking out. So, wow.
They have 14 days, I believe, Bud Light to file an objection.
Rule 72A objection. So,
what do you think Shaka's going to do?
File it.
What could he possibly say?
I bet you it won't include case law because sorry, I'm sorry. I should shut up.
No, speak.
Dave,
if there's anything you learned from this, speak your mind.
These people made my life hell. All right. Like I'm not trying to say pity me, but this shit put me in a hospital. Right. Like this shit seriously did. Lisa, how much damage this shit has done on my personal life, on my business, on everything, my whole being, and every little grimy little dig that this lawyer could do, he's done to me.
Yeah.
And any which way he can make me lose sleep, he's done. So I don't expect anything less in this objection. Whether it's just, I think it's just billing hours at this point, to be honest. I personally think this plaintiff needs to be going after a charlatan lawyer, in my opinion. The lawyer seems to be selling snake oil.
I'll tell you something. You know, that firm defended Jeremy DeWitt, and there was a lot of money there that, changed hands. That was over a pretty long period. Now, I don't know who Amir Shochet is, but I chased down as much as I could on that case because I wanted to see the correlation between the type of tactics used, for law, for submittal, and the attack part where in DeWitt's case, where they attacked the deputies and sheriff's department and the different court systems, it has a big similarity. The only thing is, Amir Shochet from that firm was the one in defending this DeWitt. And I never did figure out who Amir is. But what I was trying to do is see what correlation there is with Amir and the what kind of a relationship he had with the board down there, and see if he had anything to do with that board way back when Randall went before the board. I mean, think about it. I figured the only way he could pass the board down there to be accepted, somebody had to have influence down there because his background is such that I don't know of another state that would have took him in without influence. And I started looking at the name Shochet, and it appears in a court or in a case represents somebody in front of the Congress not too many years ago. But it appears in a lot of different things in Florida itself. I just haven't found relationships to Randall himself or whoever it was. And I just haven't had enough time. But as far as investigating backgrounds, I'm going to do that till the day I die. I just have to get better systems for search. That's all. So far, the ones I've used haven't come with the full conclusions that I needed.
Yeah, and I'm sorry, guys, to tear up during reading this. It's just so much has gone on with all this, and when I'm attacked daily, and I've been sitting here telling the truth all along. I've been trying to prove and show everybody what he's doing, how he's he's just this phony bullshit artist, and it's all for content, and and every day I come on with the same thing over and over, and it's been repetitive. Oh my God, so much repetitive bullshit. And to sit here, to watch Ray go through what he went through, to see Dave and how he was being tortured, and just like everybody involved. And originally, remember, this started with this 2 going on 3 years of what he's done to Michelle and John and Harley Grace. And this is such a, this is the recommendation. It's not sealed and it's not signed and sealed yet. But the fact that
the court usually adopts these recommendations, though.
Yeah, and to go through all this, to wait for it to be going on for so long, just to not know, is the judge fair? Is the judge not fair? We have, every day it's up down, emotional, in out, and to just like read those words, and.
Think about what's happened to, Michelle and John and little Harley, just with the CPS. Right up till a week ago. My goodness, when is this thing going to get over for those guys? They can't go to the store. They can't go to the post office in a town of 100 people. How fair has it been for that family? And I just can't help but think that there's got to be a better way for the legal system to work rather than to have these things go for years and years. We see it, we know what's right, and yet we can't get it through the courts and get it right. But I just don't understand it at all. I never thought it would ever be that way.
Thank you, Helen. You guys are awesome. And guys, you know what? You supported us this whole time. And I just want to thank you for being there. for being here, being present, supporting my channel, Super Dave's channel, Ray, Rich, everybody. You know, Robbie gets on. Tori, you know, I know Tori's. I think she's still. I don't know if she's still showing us right now because she's live right now. Tori, I love you, girl. I just, you know, you guys have been such a big part of helping us keep going and keep fighting too. You know, that, you know, we had, you know, our voices and you guys were listening to us and understanding at least where we're coming from, you know. And I mean, as we said, it's not over yet, but this is really freaking good.
Yeah, I just want to piggyback. I want to piggyback on what you're saying. I just can't thank all of you guys enough. Seriously, you guys have been a family there for me, and all of us. You've helped me through some pretty dark times, and you guys are still continuing to be there, rooting us on, making sure we're standing tall. And that means
sorry, whoop whoop. I had to. Are you dead?
Means so much to me. Means so much to me. All of you guys are like family to me. Thank you all. Seriously.
Yeah, it's.
I mean, don't we treat the people in the chat like family? They are.
Yeah,
right?
yeah, absolutely.
They are family. They've been praying for us. They've been patting us on the back. You know, one of the problems we still have.
We wouldn't have gotten this far if it wasn't for them.
Yeah.
We still have a problem out there. And that is
that's not over.
Minions are still after our families. Our families didn't have anything to do with any of this. You know,
we'll see how Jeremy rolls when the tide
returns. Our kids, they went after, in the case of Leslie out there, they went after her entire family, contacted them. She lost a job. Do you think these people are going to back off? They found a gold mine and they're still out there. I don't know what they plan next. But these people all have something in common. It's the lust for money and the hate for us guys that stood up for a family that needed help. And they're using it as a basis to attack us. I mean, within the last week, you know, they went after my family. It's terrible to wake up and all of a sudden here's another yo-yo making statements that are completely untrue. I don't understand.
Other people talking about it.
I really don't understand it.
Well, he's getting other people involved.
Yep. I'll tell you what, the one thing that kept me going in the last 6-7 months was everybody that jumped on the bandwagon and give their best wishes for my wife and myself. The prayers that were sent out, I can't help but think they all worked.
And she probably had a hand in this too. She was probably watching over you.
Oh, yeah.
Amen.
No doubt.
I haven't had many good days in since July, but I got to tell you, this is one of my happier days. But there were days where when I checked in with Lisa and you know the prayers were up, and same way with Robbie, and it's having those kind of friends out there that I've never met, and I do hope to meet a bunch of them. You know, come pretty soon here in the spring. I'll be making my trip and I'll make a loop. And as I go, I hope I can meet some of the others that has wished us well. And there's some people here in Iowa I want to meet with as well that have had my back. I really appreciate it. I can't thank Lisa enough, but she has stood up and fought this battle. I don't know.
She's been an angel to so many.
Yes. Yes, she has. And I thank the good Lord too, because he certainly has had our backs, all of us. So. And Rich, I gotta say, I love your way you can get everybody.
Take somebody off.
It's not just that. Rich, you can have an entire show of your own of just comedian enterprises. You can.
He's seriously my favorite journalist.
I really do.
And saying the things that we really can't say.
Right?
That we want to say, but we
damn.
can't say.
Yeah.
What it amounts to is some of us are a little afraid to say it. It's pretty brave to walk in his shoes. I guarantee you that is a brave guy. And if I ever wanted somebody to guard my back, I can tell you right now, it would be Rich. I would
I'll be up there. It's a beautiful memorial garden that they're building that I want to take a leak on. So I think we should go up there together.
See, there you go.
Listen, I might send you a little bottle with a little to put on there. Just
a little
don't
sample,
but it's not lemonade.
Oh, okay. Yeah. That'd be nice. I think that might have to happen.
He can get drug tests from all of us.
I'm not.
He can get a little UA from all of us.
Jeremy, I ain't effing scared of the effing birdhouse. I'm not scared at all.
I know who is the failure of the month.
Yeah, there you go.
More like the year. Yeah. Oh my God, we were just coming up with that award too. I'm sure there'll be more. We'll still continue.
Think how stupid this guy is. Think how much money he spent. And Jeremy,
no, Jeremy didn't spend it.
Do you really think he cares? I mean, do you really think he cares?
I'll tell you what. How much fun is it going to be when Germ, being the cheap fuck that he is, goes and asks Shaka for his money back?
You're gonna have to take the ring off Doreen's finger,
right? Oh my God! Maybe he's not going to get any more cash sent to him in the mail.
I wonder if he's actually working on a percentage.
We need more lawyer fees.
Yeah. And all of this is our opinions, everybody. There is nothing. Everything we are saying now is opinion, protected speech. Just want to make sure that's clear.
Yeah.
No threats are being made. Nothing. No, we're joking. We're happy. We're expressing our opinions.
Yeah.
Sorry.
I felt they realize that.
Yeah, I suppose you're right. They'll still try. They'll still try.
My day was made today. It really was. It's just, I think the thing that come the closest to make me as happy was the Christmas party out there a year ago last December. That I was pretty happy to see that come off the way it did. And, it started a new thing on Christmas Day, thanks to Lisa and all the people in there that contributed to it. It showed that this channel has a good heart and that they were intent on doing good things.
Alan,
regardless of what's happening to everybody, the good side is there's a lot of good done for other people along the way. And
we got to thank Richard, Michael, and Leslie too.
Absolutely.
They'll be next. They'll be next with dismissals.
Yeah. It was funny because when I called Richard, Leslie's calling me.
That's what I told her. Yeah. So either call Richard or call Leslie.
Leslie's calling me, and I'm like, all right, and Robbie didn't know. I'm like, what are you doing? He's like, nothing. I'm doing this. I'm like, get on my live. I got news on Fed too. He's like, what?
But I think when you were on the phone with Richard, Leslie was calling you.
Yeah, Leslie was like me. And then as I'm setting up the live, I see she says, congratulations. And I'm like, what is happening here? I'm like, is this really happening? Like, yes, Richard. I was literally like, am I seeing what I think I'm seeing? Like,
you better get a second opinion.
Yeah, because I didn't even get to the bottom of the document. You know?
I read the last 2 pages before I got off the live.
I was like, we need Ray on here. Get Ray. And then I realized somebody had said you were live. I'm like, oh, all right. I'm not going to get him off his live. But wow, Wow.
Yeah, when I was told that it was on the
Jeremy, right?
What happened, I went right away back to my emails, and there it lay.
Yeah.
That's a nice gut check.
It was a big surprise. Hard to believe at first, but
and so many. It wasn't just one person. It was multiple people.
Yeah.
Yeah. One thing about it, when one of us was kind of down, the others jumped in there and tried to help out to get our spirits going, and it certainly made a difference in how people felt. We're all individuals, and we showed different personalities out there. And the one thing we agreed about is trying to keep everything clean and do it right and follow the law. And we all did those things.
Right. You might start packing Guapo again for content. Guapo, be prepared if you're listening. He's going to be coming for you.
Wow. Sorry, Ray.
Sorry, Ray.
I was just
Harper says, pass it, Gabe.
There you go.
Wow.
Well, one thing about it, I do plan on having some fun now when I come down there. It'll be all vacation, and that means fun. And I know Gabe is going to get up there on the stage and sing with Lisa.
I'll tell you what, I've never sang karaoke. No one's ever got me go up karaoke, but I will go up on stage with you, Ray.
Absolutely. Yeah, I'll do karaoke.
I'll sing
it.
Wow.
We are going to have a party. And
Lori, Jason, Gabe, I think he's too scared to go after Guapo. Me too. I agree with you, Lori.
Yeah.
Guapo might have
he could go ahead and go after him just to have some content or something, but it'd be a big mistake. Guapo would be
oh, wait, can I say something real quick before it leaves my head?
Sure.
Wasn't he all cocky the other night saying, tick, tock, tick, tock, tick, tock? And then I made a comment in regards to it, and I said, I said TikTok in regards to Megan, and then, they're gonna have to pay the attorney fees for Leslie and Michael. That still exists, right?
Yep.
But Jeremy jumped on the whole TikTok thing. I said, yeah, but what you're neglecting to see is with all your bombshells being duds, you're still going TikTok, and you don't see that I'm the one going boom. And what do we have today, Jeremy? Your TikTok. Here it is today. Lisa's saying to you, boom. Done. You have lied and hurt so many people, and now the dominoes are falling. Starting with what? The Dan Owens, right? Dan Owens was one. Here you now fed two. Shockingly today. Shockingly. Because trust me, none of us expected this today, did we? No.
No, definitely not. Definitely not.
No, that was pretty quick, wasn't it?
Yeah, well, it seems that way, yeah. Because I just told Richard this afternoon, I said, Richard, I have so much to talk about with you. The emails and the filings. I was like, there's so much to say tonight. And now it's like, do we even need to go over that?
No, I don't think you do.
Yeah,
I don't think you do.
Yeah.
I'm really happy for Dave Helm. I mean, I out of all, everybody, for him, we all know that Dave Helm loves to run his mouth, right? Like, that's what he does. He's a commentator.
Yeah.
He loves to talk. And I'm sure under, legal request from his lawyer, he did not speak on this at all. I'm sure that was hell. I'm sure that was hell for him. I mean, seriously, I'm sure that was so hard for him not to speak on this. And he laid in the cut. He let his lawyer do the lawyering. And look at this. Not a penny's going to be coming out of his pocket. And now he can speak freely and know that he is, within his rights to say what he has on his mind. And I'm really proud of him for, how he handled that. I could never do that. That's just me. I mean, I like to talk, but props to him.
Yeah. He hasn't said anything. And that's it. The Hodunk Award. That's what we call him. We needed a title for it. God, there's so many awards we can be giving out. But no, I totally get you, Dave. Totally. Please hit the thumbs up. Let's vote who gets the Hodunk Award. I vote Martha and Germ. Yeah, Linda. Boom. There you go.
I wonder what George has to say about this.
Yeah, she's probably like, you know what? Honestly, she's probably like, thank God I can leave now.
I don't have to.
Didn't she say, I'll stay until the court cases are over? Well, this is a pretty big kaboom. So maybe she could just get up and walk and leave and, she doesn't have to deal with it anymore. But I guess he still has a couple open cases.
Do you think she's going to leave with all that money on the table that's out there yet?
Yeah, she'll get it back when she writes her tell-all novel.
Yeah.
That's my dream.
I don't know if many people will care.
I suppose. A man can dream. A man can dream.
Yeah. There you go.
I hope one day to cuddle up with that tell-all novel and just enjoy reading it. That's my dream one day. It's just to read Martha's tell-all novel.
Yeah.
Wow. Wow.
Couldn't have happened to a better person.
I'm waiting for the encyclopedia of novels to come out. There would be Sarah, Holly.
Yeah.
There's one in between. There's Martha, that school teacher up there for that. And I wonder how many on Craigslist and the dating sites are going to join in as co-writers of some of the novels.
Right.
There's a lot of stuff going on in Ohio yet, I think. My opinion.
Could be a series of movies.
Richard, all joking aside, do you think Shaka didn't see this coming?
I don't think he saw it coming this quick. I think that they might have saw it coming, but they're in trouble now. They're in deep shit because they telegraphed there's going to be an anti-slap. And I requested a referral to the bar for Shaka. So that might be one of the reasons that, for the issues that Bolitho has to look at, whether or not a referral or an admonition by the federal bar or a referral to the federal court or a referral to the Florida bar for Shaka is a sanction that's worth giving, because you can't get monetary sanctions as a pro se party normally. You may be able to get costs, like, you know, the cost of mailing, you know, $100, but you can get the a reference. You can get somebody being admonished in front of the court, or sent to the bar and referred to the bar by a federal court, and that becomes a big issue. So we'll see.
Yeah, not gonna lie, mailing gets expensive. I never realized how expensive it was to mail shit into the court. The price goes up pretty high.
Yeah.
Oh, that's right. How's it go, Derm? I've got karma to my left. I've got karma to my right. Didn't I say karma was going to rear its ugly ass end on this? And not only that, I also, if Tammy was here, she remember the other night, there's like this Neptune thing meeting with another, planet, and things happen, and it's supposed to affect Aries, which Jeremy is, and it was about old buildings crumbling down and karma. And I was like, oh, we may know something by February 20th. What's today's date? It's the 10th. It may be a little early. So he may have some more karma coming by the 20th or 25th, something. It's coming. So that may mean that Hinkle's going to sign this and make it an order. So who knows? I know some people may not believe in that, but here it is. Karma is rearing its ugly ass on Jeremy Hales and all his bullshit.
One thing about this case, it may bring one of Jeremy's dreams true. And that is, it's going to make him famous out there among the YouTubers and the people that went after free speech. It will be attached in some way or another. We just have to see how the final rolls out when Bolitho's boss goes over it and hands us either a yay or nay on it. But I'm looking forward to the very final part. And like I say, the one thing that Jeremy's wanted is fame. And he will be known for fame because this will go through the YouTubers pretty fast, however it's going to come out.
I got a couple of YouTubers I got to send this recommendation to. I know there's a couple of people I know who want to read it.
Well, remember,
question for Lisa. So will this warrant a glass, not a sip, of champagne now? I'll tell you what, when Hinkle signs this and put this in as an order and it's done, I will. And I will come on here and I will show you guys this glass I'm drinking and everything. We will have drinks together. Yes. No problem. Look who's here. Hold on. It won't let me add. There it is. Leslie?
Hey, guys. I just wanted to congratulate you guys. Don't even know how happy I am for you.
Thanks, Leslie.
Yes, thank you, Leslie.
Yeah, I was so when Michael called to tell me, and I was like, no freaking way. Hell yeah.
I didn't know, man. I didn't know. People were calling to tell me. John woke me up. He had Tori come wake me up.
Oh my God. This is awesome. And this is exactly, Lisa, what you've been saying. You know what I mean? It's like you've been preaching this, and I'm so what is he gonna say? What is he gonna say?
Right.
Yeah.
We'll find something to say. Sure.
Yeah.
You'll be next, Leslie.
Yeah. You'll be next.
Oh yeah. Well, I already told you guys it's a bogus lawsuit that he filed against us. You know what I mean? Like another bullshit. And like I said, these are Shockett's lawsuits are getting dismissed on failure to state a claim, which shows what a bogus attorney he is. I mean, that's pretty weak if you're getting your lawsuits dismissed on failure to state a claim. Shows you. You know what I'm saying?
That's true, man. Here, show display name. It's not showing.
I wonder what his reviews look like.
Right? It's not showing. I don't know why it's not showing everybody's name. It should be showing everybody's name because two of you guys are missing your avatar. So I figured if I could turn your names on, but it didn't. Anyway, that's all good.
Yeah.
But yeah. I mean, isn't this insane? I mean, failure. What was I thinking?
The state of, that means that you didn't even allege enough facts to comport with the elements necessary. You've got to be a pretty shitty ass attorney. And this is, like I said, this is the second lawsuit that was the one against Dan Owens was dismissed for failure to state a claim. And now this one dismissed for failure to state a claim. And like I said, you expect that from someone who doesn't know what they're doing, but for an attorney, it just shows you what a shitty ass attorney the guy is. He's just taking him for his money.
Yeah.
But
$487,000 is what he said he has paid to Shock It. And who knows how much cash Shock It's worth.
And that's what he claims.
487, almost $500,000. Pretty much $500,000 because what happened is he had people sending money to Shock It himself. Yeah. And then he'd also get cash in the mail.
Mm-hmm.
So, and the funny thing is, he's wondering where everybody else's money is, but no one's said a word to him. You know what I mean?
Yeah,
like, where's your fucking money, asshole? Where's your money
now?
He would have been better off opening like a putt course or something with $487,000. Would have been more useful money. At least he could have fun.
Yeah.
Do we think he even paid him that much? Probably not.
I think that's the running total since the beginning.
That's probably how much they gave him.
Yeah.
Yeah, I think that's the running total since the very beginning, since the very first cease and desist he sent to Miss Preston. I think that's just the ongoing total of all of his litigation.
Yeah. Unreal.
Yeah. No, I'm just so happy. I'm so happy for you guys because I know this has been just hell. You know what I mean? Having to deal with all this crap. And this is great. And, like Rich said, now he's gotten 2 lawsuits dismissed for failure to state a claim. He gets one more, and he's a frivolous litigant.
Yeah.
And this, don't think that this one's not going to follow him. The way that Bolitho wrote that up, he's like, there are 10 defendants, and 8 of them are pro se. It's a stain on Hales, but I think it's a bigger stain almost on Randy Shockett.
Yeah,
I agree.
It's not. This isn't real. This isn't a real federal. There's an old saying: "Don't make a federal case out of this." He made a federal case out of something that didn't belong to the federal court. Number one. Number two, that whole idea about vacation home, Florida vacation home. He's viewed as a carpetbagger. He is viewed by the federal court in the Northern District of Florida as a carpetbagger. He's pissed off all the judges there. I think he's done in that court after the Dan Owens stunt, and now these cases that are there that I think that they're all going to go against him. So I think he's kind of done. I wouldn't be surprised if he packs up and sells in Otter Creek and leaves because there's nothing left there for him at this point.
Well, don't forget, he attacked the local police, the sheriff's department, the supervisors, county supervisors. There isn't anybody there that he hasn't went after, and a town of 100 people, and he has turned that whole town upside down.
Yeah, he really has.
And when he leaves, there's a lot of stuff out there. He leaves a lot of venom and poison behind him.
Absolutely. Leslie, you see that comment?
Hold on, let me get my glasses. Sorry, I'm on my phone.
My phone keeps going.
Sorry, Mushroom Farm. Yeah, he might as well.
They're going to call him the Mushroom Man in the future. You know that's going to follow him because that's all over the internet.
Hey guys, I gotta get going.
All righty, Dave.
I gotta
see you guys later. Thank you guys, all of you. Bye, guys.
Thanks, David. Thank you, everybody. Congratulations to everybody. This is a great day.
All right, what's going on? What's going on?
We all won, Robbie. We basically won. We got to wait. You got to wait 14 days. I'm going to wait a little longer for my opinion, but
I can't hear anyone.
we're in very good shape.
Robbie,
And
now that you come back, we don't have anything to talk
know
about.
that Jeremy Hales is a loser. Literally,
Great.
that is not my opinion. That is an actual legal fact.
Yes.
Jeremy Hales is a loser.
Yes, Jim?
Loser.
With a capital L.
You do this. I can't hear Rich.
But
And he did such a
gotta
fucking
run, guys.
video.
I'm still getting over being a little sick. So thanks for having me on. We'll talk about this more later, okay?
All righty, sounds good. Thanks for coming on. Bye, Rich. Oh my goodness, guys. So wow. This is the breaking news. The breaking news. Basically it's recommended by Magistrate Bolitho that Fed 2 case get dismissed, that all the motions to dismiss be granted, and for the anti-slapper Helm, he should be getting attorney's fees. And that's it. It's over.
Remember before this case started? Remember the video where Jeremy said it was the judge's idea for him to sue all of us.
Yes.
I'm wondering what he's going to say now that this is done.
Yeah.
He's going to say bad advice was given by a judge.
Probably.
He is going to.
He's not going to take the blame. He's going to blame somebody else for it.
Oh yeah. Oh, they're going to go off on Judge Bolitho.
Oh, yeah.
It's this one's face.
They're going to go after Judge Bolitho, or
Yeah.
they're going to file something against him or something.
Yeah, it's all going to be a whole big, bullshit thing.
You guys remember he said everyone's going to be paying him the rest of their lives.
Yeah.
Oh, yeah.
He said that how many times that you guys are
I
paying
know.
him the rest of your lives.
Leslie, will you announce the Hodunk of the Year award?
Oh my god. Well, I've gotten a lot of nominees. Did you guys see? I posted those, but I think Kathy Criswell was like the number 1 nominee, aside from the obvious hodunks that we already know. But yeah,
He is really going to be going hard at this bankruptcy stuff. Yeah, he's trying, but I can tell you, up until this afternoon, he's full of shit. Everything he's saying is a bunch of lies with that.
Now that Michelle has the trustees getting an attorney, they can do, and so they might be Schitt's Creek. Might be Schitt's Creek getting a lawsuit from the bankruptcy court.
Well, here's the one thing. Jeremy's making it like this new law firm, right? They're going to go and get all these financials. They're going to go do this, they're going to go do that, blah, blah, blah. Alicia's going to jail, blah, blah. Yeah. Here's the thing. That lawyer is going to get paid 40% of whatever, money's involved, right?
Yeah.
So what Jeremy's not realizing is Michelle doesn't have any money for him to get.
No.
Where the money lies is in Michelle suing Hales and
That's
Michelle winning against Hales and getting all the money from Hales. So if he thinks that he's going to convince this lawyer, to go against, Michelle, I don't think that's good. Guys, you need to really look at the whole picture. And that's just it. The picture isn't really laid out for the bankruptcy thing. Okay, it's really not for everybody to see. It's not. Maybe because I wasn't even paying attention to really what was going on. Because to me, it's Michelle's bankruptcy. You know what I mean? It's that's her financials. Right. We know she doesn't have much as far as assets like that. But it's still none of our business. So I kind of just like that's her bankruptcy. Let them deal with that. But he made it like it's the Fed 2 case. That's how Jeremy's making that case look. And it's not like that. It's not at all. And it turns out, as big of a creditor he thinks he is, I'm more of a legit creditor, which freaks me out. I'm like, excuse me, what? I am. How is that? So, and my getting involved in that is only to protect the assets there, and I can do that because I benefited the property by adding the fence or whatever. I benefited that property, so I can go in and protect that. And if I did do that, that would be protecting everybody else who got involved in helping with that.
Absolutely.
So that was me going, if that's the case, then yeah, I will sign up for that. So that's kind of how I've been brought into it. But he's going to go hardcore with this now. And I'm going to be there to prove once again he's full of shit. Okay? So don't worry about it.
He's going to really
he's really going to hate me now. What do you think, Leslie?
I think he's gonna definitely. I think it's gonna be great, Lisa. You know what I mean? You're gonna be the thorn in his side.
Do I need to get security to stand outside my property right now?
I would say you better get something. You better have plenty of pepper juice on you, because I'd be leery about anybody that you don't recognize that comes anywhere near your property or your car.
Let them come.
Yeah.
Let them come.
No, don't invite it. If you do, you'll have so many on your doorstep. You won't be able to to walk over the top of them to get out of your house. Don't period. It doesn't work that way.
Yeah.
Well,
this is going to be really interesting.
If you don't think they're crazy, I'll send you a couple of channels.
I grew up differently.
You can look at those channels. And
I grew up differently.
Yeah.
Well,
guys,
I don't think we can defend ourselves until that crowd gets in and they encircle you.
No,
it doesn't work very well. And I've been in.
Well, you just keep
in a circle of people that want to get pretty bad.
You get into a fight with 4 or 5 guys. Just make sure the first one you peg remembers you the next day. Who cares about the rest? Just make sure one of them remembers you in the morning. That's it.
Yeah.
I don't. Yeah, that's it.
Wow. All right, guys. So what I'm going to do is, because we did some breaking news, and I basically jumped out of bed for this. I did. I was sleeping. I'm sorry.
I was so excited. No, I hear you, Lisa.
I got a couple things I got to do, and I'm supposed to be live at 10 o'clock. So I think what I'm going to do is I'm going to take a break for an hour, and I will be back here at about 10:30ish. Whoever wants to come on can come on tonight. I just need to go do a couple of things for a little bit.
I wouldn't mind coming on. I'm in a good mood, so I won't destroy your channel.
So it will be.
I was gonna say everybody's at my house right now, so I gotta go because we've all got the flu, so we won't be going live this week. But anyway, yeah.
Well, I hope you all feel better, Leslie.
Thanks,
Lisa. Hi, Leslie.
I have to honestly say congratulations. I couldn't be more happy for you guys.
Hi, Leslie.
Okay, bye, guys. Hey, Robbie, congrats, everybody.
Thank you.
No, I'm not going back to bed.
Yeah, you will.
Yeah. No, I'm not. I'm not going back to bed. I can't. Are you kidding me right now? There's no way. I gotta go tuck Gabe in. But anyway, no, guys, I'll be back. So look for me back around 10. Give me 10:30. Don't tell me I'm late if I'm 15 minutes late or whatever, but I'll be here by 10:30.
Well, I
all
won't
right?
be able to sleep yet, so give me a...
I'll send you a link, Ray.
Thanks.
All right, guys. We'll see you. We'll see you in a little while.
Right.
Bye-bye. Bye. Bye. Bye.
Bye.
Bye.